Thank you.
Mr. Ouderkirk, good morning.
Good morning, Your Honors. May it please the Court, my name is John Ouderkirk, and I represent the juvenile in this case. I realize this may be a little out of the ordinary, but having heard Mr. Shaw's arguments, he advanced a number of mine in advance of my arrival. If it would be acceptable to the Court, I would like to just continue on and expound on some of the arguments that have already been made rather than reinvent the wheel.
You may use your time any way that you'd like to, and if we have questions, we can ask them of you, Mr. Ouderkirk.
It's a very different case, Your Honor, in that this case is considerably more focused. A great number of the questions that the Court had for Mr. Shaw were resolved at the trial level in this case. There was an in-camera hearing as to who the first complaint witness was. There was a specific finding by the trial court that the sister was the first complaint witness. So the questions the Court was grappling with in the earlier case were in fact resolved. I think where that leads me is to a remark that was made in the prior case about the difference between first complaint and best complaint. And my observation on that distinction is that what the Commonwealth is looking to do in their argument is to say the first complaint is the first inculpatory complaint. And I submit that, at least from my reading of the King case and from the rationale in the King case, that was not what this Court meant to say.
Well, it's got to be a complaint about a sexual assault. That was the whole underpinning of King.
And this was.
Was it?
Except it was
the first complaint
as to this particular participant.
Did the first in the first complaint, does the witness say that she complained that she was sexually assaulted by the defendant?
I believe the exact language.
No, she said she was sexually assaulted by somebody else, and this defendant was present, correct?
In the first complaint, not even that.
No.
But to answer Justice Cordy's questions, the ruling by the trial court was the complainant was of the belief or was conveying to the first complaint witness that something had happened. She may not and probably did not use specifically the word rape. She may not have used the word rape, I should say, may not have used that word specifically. This belief that something of that nature happened, I think your argument as regards that issue, Ms. Calkins, regarding the first complaint, is a fair one regarding her perceptions.
The answer is no. Isn't the answer no?
Well, I think what the trial judge was saying there, if someone...
What was the testimony? Can I have the testimony?
The testimony was that, well, unfortunately, there are three different complaints to the first complaint witness. The testimony was that there was an initial interaction between the sister and the complainant in which nothing was said about the assault whatsoever. Then there was a second interaction between them when they're getting ready for school the next morning after they've had breakfast, where the sister discovers the hickey on the neck. And the complainant says to the first complaint witness, the other defendant, the adult defendant, did this to me. That was it.
Scar on her neck.
The hickey on her neck.
Well, it could be hickey, could be anything.
Well, she described it as a hickey. Okay. And I think it was very clear between the two girls talking that they knew what it was. Then there's another interaction between them when they're walking to school. And at that one, she says, and I do not recall her exact words, something to the effect that the other defendant had taken her and they'd been out drinking and that something bad had happened. And then there was yet one more interaction between the complainant and the sister where she says, I know something, I've got to tell my mother that something bad happened, but I can't do it. Will you call my mother and tell my mother for me that this other defendant did something bad to me? It was, no, the word rape was never used.
Not only rape, sexual assault wasn't used. I mean, something bad happened.
Something bad. Well,
that's the best you got.
That is true. We would have to concede that something bad, we need to tell my mother.
And then she told her mother and then laid out what happened, or
Correct.
which was a sexual assault.
In there, because I think this is your argument, and implicit in there is that they were talking about some sexual assault, right?
Correct.
But of the other defendant, right?
But of the other defendant.
Okay. So if you just look at first complaint, and we're talking about this defendant, isn't the first complaint to the mother?
Well, that raises a very interesting question, because that comes into play with what I think we all would agree, that the Commonwealth has an obligation to make available exculpatory evidence. And this, in fact, would be exculpatory evidence. She made complaints to lots of people, but not about this one.
But isn't it important that in the first complaint she didn't say anything about sexual assault? That's the importance of it, and could be one of the rationales for sticking to a strict interpretation of first complaint. Because if first complaint doesn't include sexual assault, well, then maybe this is
I agree. I agree wholeheartedly, and that brings me to a different point, but I'd like to answer your question first and then go back to my point. This court already dealt with that situation, albeit from the perspective of the situation being the mirror image. But this court already said, if there's a situation where there's an inconsistency between the first complaint witness's testimony and the complainant's testimony, well, that's fair fodder for, in King it says cross-examination, because I don't think the court expected that perhaps the Commonwealth would be impeaching the first complaint witness of its own first complaint witness. But again, the Commonwealth had perfect opportunity to examine the complainant on the fact that what she told the first complaint witness was different than what she testified to on the stand. King already provides a mechanism for how we deal with that situation when it comes up. And
I take it that at least in this case, there are lots of reasons that you can imagine why a child doesn't say to her best friend, I'm talking here about the sister of your client, all of the details, may even hesitate, and she can so testify. I felt uncomfortable. I didn't want to spell it out. I was, still in shock, whatever she wants to say.
absolutely. And my argument would be that certainly there are probably dozens of reasons why the complainant would not want to get into details with the sister. But one of those reasons could be because, in fact, this particular juvenile didn't participate. And the examination process in front of the jury...
The sister who was present, she's not a juvenile. When you said this particular...
Well, she was indicted as a youthful offender.
No. Who, your client?
The sister.
The sister of the, I'll use the word defendant, if that's more clear, even though she was a juvenile.
Okay.
Right.
She was a juvenile at the time.
Correct, and was indicted as a youthful offender. And it was her sister that was the first complaint witness.
Okay.
Right, and I believe the indicted one was 15 or 16 at the time.
Now, there was some inconsistency about whether or not the defendant was present or not, correct?
Initially, there was discrepancy about whether the defendant was present or not.
Could the judge have reached the conclusion, exercising his discretion, that actually the person who was offered as the first complaint witness, who would have been testifying, really providing information against her own sister, was not trustworthy, and exercising his discretion, say, she testified this way, she testified that way, so I won't identify her as the first complaint witness.
I think that gets on the edge of a slippery slope, and the slope being that if, in fact, we are going to equate I'm not sure that we can equate the fact that she was inconsistent with the fact that her testimony is untrustworthy. But even if we were to go that far and say that inconsistency equals lack of trustworthiness, at a certain point, doesn't that fall back as within the purview of the jury to evaluate the credibility and the trustworthiness of one particular set of facts as testified to by one particular witness?
I mean, isn't the whole purpose of the first complaint doctrine, at least one of the purposes, is to get out the first complaint, because the whole situation involving the first complaint is important, exactly what was said and to whom. And if we start eroding it by saying, well, it's not the first complaint, maybe it's the second one in this case, then aren't we just undoing what we just wrote about in King?
Well, I agree, and I think that part of that, and I realize I don't want to spend a lot of time addressing the Amici briefs, but part of what the Amici were talking about is the same as what the Commonwealth was talking about, which is saying we don't necessarily want to resolve these issues the way the court told us to resolve them in King. Both the Commonwealth and the Amici are in effect asking the court to do something the court has already done. The court said we're not going to get involved in this promptness, freshness situation anymore. It doesn't matter whether it's prompt or whether it's not prompt. What it matters is we're taking the position that even though we don't like it or we may not want to, we have to acknowledge the hue and cry doctrine, and so we will. And this is a good way to do it without getting into all of the issues that the Amici raised in their briefs about the fact that it takes time to
Mr. Oderkirk, I take it that if one stuck to, at least what I understand, the purpose of the first complaint doctrine, this child said to the sister, in words or substance, something uncomfortable, unusual, not very nice happened to me last night, correct?
I believe she said something. I believe she said he did something bad to me.
So if there was ever a suggestion by anybody that when she gets up to testify and tells in painful detail what was done to her, nobody could turn around and say, well, you went back to that house and you never said anything to anybody, did you? You couldn't make that argument in the face of what the sister said. So if you admit that evidence, it serves the purpose of what the underlying theory of the doctrine is, namely, somebody remains silent. This child did not remain silent. At almost the first opportunity, she says, something bad happened to me.
But does something bad happen to me equate to something of a sexual nature happen to me?
Maybe not, but she then testifies to what happens to her. And she testifies painfully, which is what she's going to have to do.
To answer Justice Ireland's question, no, it might not mean that, but it certainly appeared to me, it certainly appeared to everybody involved in the trial from the context that, yes, what she meant when she said something bad was done to me meant something of a sexual nature. But if you were to read the printed word on the page, certainly you could make the argument that something bad to me was I dropped a heavy can on my toe and broke it.
It was he did something bad, and then you go to Justice Botsford's question, which is, when did she first say that she, in other words, the sister juvenile who was adjudicated delinquent, when did the victim implicate that person?
Third and fourth. If you count all of the disclosures to the sister as one, she's first. Mother.
No, you don't discount them. You don't count them all as one.
Well, then we're up to sixth or seventh by the time you get to the DA, which is where the first time she said, this juvenile actually touched me. We went through nothing. We went through some disclosures where he did something bad to me and she was there. And then when we finally get to the interview with the district attorney and the interview with the police detective, she says, and this juvenile actually touched me as well.
Say to her mother that your client did anything to me?
That she was there. That she was there. And it was later in the interview with the police detective and I believe it was a nurse practitioner that did the first DNA swab.
That was first complaint.
No one was consistent.
Do you think it would be appropriate or fair to take what you say, that the first complaint is to the sister, who I might suggest would be somewhat adverse to this, but okay. First complaint is to the sister, no mention of your client. She's on the stand at trial, the victim, and there's cross-examination about, well, all you said was maybe something bad and then only this other person, and you never, ever, ever mentioned the sister. She could never say, well, I said 2 hours later that she was there. So you would say, no, all of that is out.
No, I would not say that at all. And that brings me back to the answer to Chief Justice Marshall's question. I believe you said after she goes through the painful testimony, nobody could go back to her and say, well, you went back to that house and didn't say anything. And I would submit, under the way things are right now, the answer is, if you thought tactically that was a good question, you could ask her that, but you can expect the other side is going to say, why?
Correct.
And why is ultimately, I submit, going to be the answer that's going to be persuasive to the jury on the question of credibility, not so much
So what we
whether
actually
or not.
said in King is what we want, what is pertinent to the jury's understanding is what motivated the victim to come forward and is the most useful in assessing the victim's credibility. In other words, why? And that's exactly what will happen. You don't, it's not to flesh out whether what she told was all the details to the first person.
And that is what did not happen in this case. Rather than get to the question why, we bring in this other witness and say, now we're going to call this witness the first complaint witness, because now this witness can testify that the complainant said that this one was involved, and we skipped the central part of that doctrine in King, which was the simple solution is ask the complainant why. I see I am over my time.
Thank you, Mr. Odekirk. Ms. Lugo, good morning.
Good morning. May it please the Court, Kimberly Rugo, Assistant District Attorney for Middlesex. This is not a case where the Commonwealth was shopping around for the best witness, the witness that would most corroborate the victim in this case. Limiting the Commonwealth to the defendant's sister as our first complaint witness in this case would have completely undermined the purpose of the first complaint doctrine. There is no basis to believe that the defendant's sister in this case could offer any meaningful testimony about the fact that the victim
What do you say
disclosed.
was the basis for the first complaint doctrine?
The basis for the first complaint doctrine is twofold, as Justice Marshall already stated, to refute any false inference that silence on the part of the rape victim suggests fabrication.
So we satisfy that by having the sister testify?
Well, no, I don't believe we do, because the defendant's sister on voir dire, and even before trial, we were aware that the defendant's sister was going to deny altogether that the victim disclosed that she had been raped. The defendant's sister...
Well, maybe there should have been a separate trial.
They were tried separately, Your Honor.
Okay, they were tried separately. So, all right. So your argument would be that because she didn't mention the sister in the first one, that it wasn't a complaint.
The defendant's sister didn't even... Not only did she not mention this defendant at all, she did not mention the fact that the victim disclosed to her that she had been brutally raped.
I understand that, but that it seems to me that the purpose is fabrication. So there's no question. I mean, fabrication is when you don't say anything. You don't. It seemed to me that that's really what the first complaint doctrine goes to. Why would somebody remain silent? So maybe you disagree with me in that, and to say what you really want to do is to say I was raped as opposed to something bad happened to me. But I think where you may be on stronger ground, and it's a little unusual, is that in fact we have a claim here by the Commonwealth that 2 people sexually assaulted this child. And so then it seems to me, at least there's a reasonable inference, although we've never, to my knowledge, addressed it directly, I don't think, that you say, well, when was the first complaint that this person did something bad, sexually assaulted me, raped me, or it might be that simply aided and abetted. I mean, if there was not an actual rape, correct? And that, you would say, in this case was when the victim told whom the first time? That this defendant,
there's 5 indictments in this case altogether. So 3 alleged joint venture with the co-defendant, and 2 were specific individual indictments against the defendant.
That she actually, she was the principal.
Correct. And on voir dire, at least the defendant's sister said that she believed that the victim had said to her that the defendant was present.
Okay, so maybe you get that for the joint venture indictments.
Correct.
And then if the Commonwealth, I assume after a grand jury, had indicted that this sister, the juvenile offender's sister, had in fact herself sexually assaulted, not just by participating or watching or inducing her to come over to the house, whatever it was, but had herself touched her in some kind of way, then you look for that.
Correct. And the victim's mother in this case was that person. The victim's mother was the first person that the victim disclosed that she had been sexually assaulted by this defendant.
Now, if that is the case, if we agree with you, do you then permit the first complainant in these circumstances to testify about everything? So the mother now, she's a first complaint witness for only part of the indictments. Can she testify about everything?
I absolutely think yes.
Okay.
And
you would say King says that she can do that? I
do. And I think we have to keep in mind the purpose of King. And the purpose of King is, as we already said, twofold. The first we already talked about. But secondly, there are many assumptions out there unknown by the fact finder that they hold stereotypes about these victims.
Yeah, but this wasn't one of those assumptions. There's a perfectly good explanation as to why she did not tell the sister of the defendant that the sister was there. And it's an explanation that everybody can understand. It's not one of those stereotypical kind of things.
Well, the defense made a big deal on cross-examination of the victim about how the victim failed to disclose that this defendant orally raped her and how much time it took her to actually disclose this. So that was a point of attack by the
I'm not suggesting in any way that I disbelieve the victim in this case, or the complainant, whatever you want to call it. I'm not suggesting that at all. But just we're all assuming that the second defendant, the female defendant, call it, is guilty. Just suppose that it's true that the second defendant either wasn't there or didn't do anything. Then the first person she told was this sister, and we have no way of knowing whether what the sister is saying is true or not.
Well, that lies within the discretion of the trial judge, as I believe that you already stated in King. And if you look at, and the King exercised, or the judge exercised that discretion.
Well, we did say, for example, so with, and you've got a very good judge here. We did say, for example, then you've got unavailable. She's not unavailable. Too young. How young was she? The sister? 13. So at the time of trial?
At the time of trial, she was 16, I believe.
Okay, too young to testify meaningfully.
Well, all of those
judge
examples
explain
that...
his
No, and
reasoning?
she's not incompetent because she's testifying, correct? The sister, the 13, the younger sister.
There's no claim that the witness was incompetent to testify.
So it all hangs on whether by, for example, we meant...
Did
Really?
the judge explain
Well, you're
his...
essentially, it seems to me, you're hanging your hook on the fact that this particular witness was an adverse witness, was a hostile witness?
That's certainly a factor. There's so many reasons, and there's so many reasons why the judge properly exercised his discretion in allowing another witness to testify as a substitute. And one of those reasons is the fact that she was an adverse witness.
Plus, she didn't say anything about this defendant.
Absolutely, absolutely.
If what you're saying is true, what this all leads to is that the first complaint witness is going to be that person to whom the victim gave the most complete details.
Well, no, I disagree with you, Your Honor. And this is where the judge has to exercise his discretion in keeping in mind that this court put importance on the initial disclosure and balancing that with the underpinnings and the purpose of the doctrine. So there lies a happy medium.
But the purpose of the doctrine isn't to inculpate anybody. The purpose of the doctrine is simply to give the complainant a chance to say, yes, I did tell someone it happened because I told someone.
To think about it in a different way, if you go back to the basic rule, the evidentiary rule on which this first complaint doctrine was based, it was based on an exception to the rule about prior consistent statements. So that presumes that the statement, the substance of the first complaint witness's testimony is going to be sufficiently consistent with the victim's disclosure.
But that's assuming that the defendant is guilty. That's the trouble.
Well,
you make
no.
that assumption because maybe I'm not saying that I disbelieve the victim, but maybe this defendant isn't guilty.
Well, and the defense certainly has much fodder for cross-examination like in this case, and he did, and in fact didn't even cross-examine the defendant's sister once we called her in our case in chief.
Am I looking at this too simplistically? If the complaint to the sister said nothing about this defendant, how can it be the first complaint? Isn't that the end of the case? You then go to whatever witness was the one who received the first complaint.
That's a very good point, Your Honor. And
Let's take that argument to the extreme. Let's take that argument to the extreme. I mean, so someone discloses, yes, there was a sexual assault, right? Names the person who participated, so we're talking about the same event. Doesn't mention that anyone else is there. 6 months later, just before trial, mentions to the district attorney, yes, by the way, there was also someone else there. So now the assistant district attorney becomes the first complaint witness against this new person? I mean, how is that first complaint in any way?
again, there are so many possible situations that could arise here, and I
But
think
that's
that
not
this
this
court,
case.
But the one thing that this was never designed to do was to corroborate the testimony that the victim gives at trial.
I completely agree with you. However, on direct examination, the doctrine is based, as I said, on a prior consistent statement. So
The
at
doctrine
least
is
as far
I mean,
In terms of
that's a useful way to say it. It's hearsay. It's hearsay. And then we have certain exceptions to the hearsay rule, of which one is prior inconsistent statement. We have others. I mean, all kinds of exceptions to the hearsay rule. One of the exceptions isn't a prior, but this was not allowed in to allow in a prior consistent. This was allowed in for a different reason. And of course it had to be somewhat consistent, because if it was inconsistent, it might have come in anyway.
If you put a name on this doctrine other than first complaint, it would have to be first complaint against the defendant.
Yeah, but
No, wouldn't it have to be first complaint of sexual assault?
Well, I think King has defined first complaint of sexual assault, and I think you can break it down for a defendant.
Why does it have to be first complaint of sexual assault?
Well, that's what we're talking about. That's what this doctrine that we've had for however many years has existed. That's
But if it's not against the defendant, it's not a complaint about him, or in this case, her, at all.
But it's a complaint about the sexual assault, which is the same incident we're talking about.
But isn't the issue here, isn't this really a question of whether the judge abused his discretion in allowing someone who the judge thought was not the first complaint witness to testify? Did the judge explain his logic?
Oh, yes.
Absolutely, Your Honor. He makes a 3-page or so ruling. It doesn't come until way late in trial, the third day of trial. And he essentially finds that there was no meeting of the minds between the victim when she disclosed the rape and the defendant's sister. And coming down to the apt conclusion that this would have prevented, had he not allowed our motion to eliminate to substitute, it would have precluded the Commonwealth from calling first complaint, admitting first complaint evidence altogether, and therefore completely gutting the purpose of the rule. So we're stuck with then, if he had not allowed our motion to eliminate, we're stuck with not only the unknown assumptions by the fact finder about the victim in this case, but also all the attacks by the defense that this victim dreamt this assault. She dreamt it up.
But it's not a question of stuck with. It's a question of whether or not you're going to be able to get to inaccurate assumptions. I mean, I know you want the best evidence, but she's going to testify, correct? She's going to testify. And notwithstanding the fact that the defendant, I haven't looked at the trial transcript, but as I understand it, the defense counsel said you never mentioned her, you never said anything about it, right afterwards. I mean, that's, very obvious cross-examination. The jury were not persuaded by that. The jury, no, this is...
There was a bench trial.
Bench trial, that's right. It's before the trial judge. And he says she's guilty or she's adjudicated.
You're right. And if I could make another point about, you had made a point earlier about the purpose of the rule is not to corroborate, and I would suggest that I totally agree with you. The jury instruction contemplates that it's for the fact finder to assess whether this supports or detracts from the victim's claim of rape, and that presumes that the defense is going to have to be able to cross-examine the first complaint witness on, and the complainant for that matter, on all the existing inconsistencies. But if the Commonwealth is forced to call an adverse witness, it guts the entire rule altogether.
Well, maybe that's why other states say the only thing that you can permit a first complaint witness to testify to is, yes, she told me, and then Justice Cordy would say she told me about a sexual assault. I'm not saying Justice Cordy. In King, we talked about a sexual assault. Yes, she told me about a sexual assault on such and such a day, period, and nothing more. Not who did it, what they were wearing, the time of day, anything like that.
This court already said in King that the details and circumstances and the manner in which the victim discloses is all very important information.
No, I understand that, but I'm saying maybe we should learn that, 49 other states, if that is correct, there may be a good reason to do that.
Well, I think this court already considered that in King and rejected that. And
Could I ask you a factual question? I take it your position is the mother is the first complaint witness here, all right? Yes. The answer is yes, right?
Yes, sir.
She is the first complaint witness?
Well, I mean, I think there's alternative arguments.
That
she was properly allowed as a substitute witness.
Okay.
And also...
Either one of those. But the complainant did not tell her mother that the defendant indecently assaulted her. Is that correct?
That's not correct. The victim told her mother that this defendant and the co-defendant raped her. She, according to the victim's testimony, could not recall the details of what she disclosed to her mother, but at least the fact of the complaint as to this defendant was disclosed to the mother. And the mother did testify to that at trial. And importantly...
So they testified to that in conclusory terms. My daughter said that the defendant raped her.
The defendant and the co-defendant had raped her, that they both had raped her. But importantly here, the Commonwealth didn't even get the full benefit of the first complaint doctrine because the victim's mother never even testified to the details of what her daughter disclosed to her.
That's not going to the root of my question. If, in fact, the mother had simply been told that the defendant was present, and it wasn't until a subsequent police inquiry where the complainant even mentioned the fact that the defendant participated, not just being present, but participated, would you say that, well, it would be the person to whom she finally said that the defendant was the first complaint witness. Is that the doctrine you want us to adopt?
Not necessarily, but in this circumstance, I actually think that could possibly be the first complaint witness.
Well, in this case, where I take it, the defendant did make a big deal out of the fact that the victim did not implicate the defendant in the statement made to the defendant's sister, and that she was making it all up. Doesn't that doesn't that provide the basis for the mother to testify as to a prior consistent statement, apart from the first complaint doctrine?
I think that I'm not sure how to answer that question. I'm actually not sure of the answer. And in this case, the posture of the case is unique in that some of the evidence was sort of conditionally allowed, and the judge denies our motion in limine, and that we have the defendant's sister testify, and then the motion in limine is actually allowed after the fact. So the order of witnesses and the order of the judge's ruling, I think, doesn't. I understand your question, but I think doesn't come into play here.
The judge's ruling wasn't correct, but perhaps for a different reason. If it wasn't correct, as admission of a prior consistent statement.
I'm not sure I understand your question, Your Honor. I'm sorry.
The defendant, I assume, cross-examined the victim on the subject that she didn't mention the defendant, the female defendant, when she spoke to the sister. Is that right?
Well, interestingly, the defendant's sister was not cross-examined at all.
Okay, not interesting. That's good tactics, I would say. Because what I was going to say is the defense is put in a very tough place, because once the defense starts cross-examining the victim's sister, the defendant's sister, and saying the victim didn't say anything about the female defendant, then the defense would have opened the door to what Justice Spina just is asking you, that to get in a prior consistent statement. But if the defense doesn't ask it, then you can't get it in. Because there's been no prior inconsistent statement, which is the foundation for the prior consistent statement.
Well, I guess within that all goes back to it's in the discretion of the judge to allow these things in or not, and to make that determination whether or not it was inconsistent or it wasn't.
Was the victim herself questioned about the fact that in her first statement she didn't mention the female defendant?
Yes, she was.
Okay, then
yes.
It would still come in as prior consistent statement.
Thank you, Ms. Lugo.
Thank you.
We'll take a short break.